Okay, check. Good evening, class. Sorry I'm not able to meet you today because I have to attend a graduation of my kid. So, asynchronous muna. Since this is the last lecture naman na hindi nyo kailangan mag-recite, bigay ko na sa inyo to. I'll be discussing the notarial practice, rule, and judicial ethics. Okay, let's begin. Okay. Based on the notarial practice rule, what is the duty of a notary public? Well, basically, it is his duty to attest the genuineness of any deed or writing. It is to attest the genuineness of any deed or writing. Next, based on the same rule, what are the qualifications of a notary public? First, he must be a Filipino citizen. So, may citizenship requirement. Second, may age requirement. He must be over 21 years old. Third, may residency requirement. He must be a resident of the Philippines for at least 1 year. Other requirements include that he should maintain a regular place of work or business in the city or province where the commission is to be issued, and he should also be a member of the IBP, Integrated Bar of the Philippines, in good standing. This can be proven by clearances from the Office of the Bar Confidant and the IBP. So again, let me state that again. He must be a member of the Philippine Bar in good standing with clearances from both the Office of the Bar Confidant of the Supreme Court and the Integrated Bar of the Philippines. And last, he must not have been convicted in any instance of any crime involving moral turpitude. Next, what is the term of office of a notary public? It is 2 years. When does the term of the office Again, when does the term of office for a notary public commence? So, kailan siya magsisimula? It's counted not on the day that you have applied for a notarial commission, but on the first day of January. So, January 1st of the year in which the commissioning is made. So, for instance, if you applied for a notarial commission in March, para magre-retroact siya to the 1st of January on the same year. So if you applied for a notarial commission on this year, March 2023, magre-retroact siya to January 1st of 2023. Can the term of office for a notary public be revoked? The answer is yes, it can be revoked. How long? So if it's revoked, how long in advance can a notary public file for a new renewal of application? So based on the rules, at least within 45 days before the expiration of the notarial commission, pwede ka na mag-apply for renewal. What is the purpose of notarization? Well, based on the rules, it is to convert a private document into a public instrument, making it admissible as evidence without the necessity of preliminary proof of its authenticity and due execution. What are the notarial acts that a notary public can perform? So, a notarial act that a notary public can perform would include acknowledgements, oaths, affirmations, jurats, signature witnessing, copy certifications, any other act authorized by the notarial rules. Yun. So, I think you have a subject and forms. Doon nyo na maiintindihan kung ano yung kaibahan ng acknowledgement sa jurat at kung kailan siya ginagamit. What situations can a notarial act be performed outside the notary's regular place of work or business? Kasi, general rule, a notary can only notarize documents in his place of business. So, ito yung exceptions. So, on exceptional occasions or situations, a notary can perform notarial acts in public offices, convention halls, similar places where oaths of office may be administered. Second, public function areas in hotels, similar places for signing instruments or documents requiring documentation. Third, ito exceptional cases lang to ha. For instance, in hospitals or other medical institutions where a party to an instrument is confined or andun siya for treatment, hindi siya makalabas since kailangan nga na nandun siya sa presence ng Notary Public. Fourth, any place where a party to an instrument or document requiring notarization is under detention. So, ibig sabihin, pwede siya sa detention facilities or pwede siya sa like city jail, sa Monte, or sa holding facilities ng NBI, BI. Anyway, what disqualifies a notary public from performing a notarial act? So first, ang assumption kasi pwede kang magnotaryo absolutely. So pwede mong pag yung nanay mo may ginawang deed of sale, yung for example parents mo, nanay or tatay mo, so yun na lang ipapanotaryo kasi sila naman nagpaaral sa all throughout law school. So hindi ganun, bawal yun. So first, bawal ka magnotaryo if you are a party to the instrument or document to be notarized. Second, if you are receiving a commission or a fee or a consideration aside from the notarial act or yung act na ginagawa mo, bawal ka magnotaryo dun sa document na yun. At eto na, syempre bawal magnotaryo kapag isa sa mga parties ay asawa mo, spouse, common law partner, ancestor, descendant, or relative by affinity or consanguinity within the fourth civil degree. What are the limitations for a person to have a notarial act performed on their behalf? Okay, so what this question is asking is ano yung mga requisites for a person na nagpapanotaryo. So the person must be in the notary's presence personally at the time of the notarization. Second, is to be personally known to the notary public or otherwise identified by a competent identification of evidence. Competent evidence of identification. Third, the person asking the person should not engage in unlawful or immoral act or transaction. So yung pinapanotaryo dapat niya is hindi dapat based sa isang unlawful or immoral na act or transaction. Fourth, he should demonstrate knowledge of the consequences of the transaction. So, dapat alam niya kung ano yung ginagawa niya. And last, he must act on his own free will. So, walang hindi siya pinilit or walang force na nangyari. What actions are prohibited for a notary public? Okay. As a notary public, bawal ka na mag-execute ng isang certificate na you believe to be false or naglalaman ng false information. Second, you are prohibited from affixing an official signature or seal on an incomplete notarial certificate. Third, you're prohibited from notarizing a blank or an incomplete instrument or document. So, hindi mo pwedeng ilagay yung seal mo tsaka yung stamp mo doon sa isang blankong papel. Fourth, bawal kang mag-notarize ng document without the appropriate notarial certificate. So, kung wala kang notarial commission, bawal kang siyempre mag-notaryo. Okay, who can inspect an entry in a notarial register? First, what is a notarial register? Ito yung libro ng mga nagnonotaryo kung saan nila nilalagay or nilalag lahat ng mga documents na notaryo nila. So, who can inspect an entry in the notarial register? Well, any person can inspect an entry in a notarial register. Next, what are the requirements for inspecting an entry in the notarial register? First, yung mag-inspect, his personal identity should be known to the notary or proven through competent evidence of identity. Second, the signature or recognized identifier of the notarial register should be presented. Third, should specify the month, the year, the type of instrument or document, and the name of the principal na he wants to inspect in the entry of the notarial register. Last, he's only allowed to access a limited specified entries. So, hindi lahat pwede niyang bulat-latin. Under what circumstances can a law enforcement officer examine the notarial register? Okay. Based on this question, under the rules, well, a law enforcement officer may examine a notarial register, but only in specific cases. For instance, pwede lang yung examine yung notarial register in the course of an official investigation or by virtue of a court order. So, dalawang instances lang. In the course of an official investigation or by virtue of a court order. Next. When can a notary public deny access to the notarial register? So, the general rule is pwedeng inspect ng any person ang isang notarial register subject to certain conditions, except when the Notary Public can deny access to the notarial register. Kailan nangyayari yon? If there is reasonable ground to believe that the person has a criminal intent or wrongful motive. So, basta pag perverted yung yung purpose ng pag-inspect ng notarial register, and it is apparent sa Notary Public na gano'n nga yung intention niya, yun, pwede niyang i-deny yung access. What is a notarial register? Yeah, ito yung sinabi ko kanina. It is a permanently bound book with a numbered pages containing the chronological record of the notarial acts performed by the Notary Public. What are the requirements for recording a notarial act in the register? Well, tignan nyo na lang dun sa Notarial Act Rule. Doon naman yun eh. First, yung entry ng number, page number, date and time ng Notarial Act, type of Notarial Act, type of description of the instrument, title or description of the instrument or document or proceeding na nangyari, the name of the principal, competent evidence of identity known for unknown signatories, name of address of credible witnesses, yung fee na charge mo, the address where the notarization was performed if not in the regular place of work, any other significant or relevant circumstances dun sa Notarial Act, and the reasons and circumstances for not completing a Notarial Act, details of request to inspect or copy the entries if a request for inspection was made. Now, kung contracts naman yan, a brief description of the substance of the contract, records of a proceeding, yun, ganun. Who should sign or affix a mark in the notarial register at the time of the notarization? So, sino yung mga pipirma sa notarial register? It would be the principal, the credible witness affirming a principal's identity, witnesses to a signature by thumb or other mark, to a signing on behalf of a person unable to sign. What should the Notary Public certify at the end of each week in the notarial register? Okay, so weekly kasi. According to the rules, the Notary Public should certify at the end of each week yung sa notarial register mismo. You should indicate the number of instruments or documents executed, sworn to, acknowledged, or protested before the Notary Public. What should be forwarded to the Clerk of Court within the first 10 days of the following month? Yeah, ito yung parang reportorial requirements ng isang Notary Public. So, kailangan mo ipasa sa, well, depende sa court, no? Some, they do strictly adhere to this rule, yung iba hindi naman. So you have to submit certified copies of each month's entries and a duplicate original copy of any acknowledged instrument or a statement if there are no entries to certify. So kaya may kopya parate yung nagnonotaryo kung magnonotaryo kayo, di ba? What is the jurisdiction of a Notary Public in a province? Yung jurisdiction niya is coextensive within the province. What is the jurisdiction of a Notary Public in the City of Manila? Oh, dun lang siya, sa City of Manila. So, hindi ka pwede magkaroon, take note, importante to, lalo kung bagong abogado kayo. Feeling ng iba, pwede silang mag-branch out ng notaryo from one place, one city to another. Kung meron ka sa may bahay kayo sa Rizal, tapos may bahay din kayo malapit sa place of work nyo sa Makati, hindi kayo pwede magkaroon ng notarial commission sa Rizal at Makati. Isang place lang, isang jurisdiction lang. Bakit? Can a notary public perform a notarial act outside the regular place of work and business? Okay. Connected doon sa previous question, syempre hindi. A notary public shall not perform a notarial act outside the regular place of work or business. Normally, kukuha ka lang ng notarial commission within the territorial jurisdiction nung court na pag-a-applyan mo ng notarial commission. For example, yun nga, sa City of Manila. Doon ka lang pwede doon ka lang pwede mag-notaryo, hindi ka pwedeng lumabas. Under what circumstances can a notarial act be performed outside the regular place of work or business? Na-discuss na natin kanina yan on certain exceptional occasions or situations based sa request ng parties and within the Notary Public's territorial jurisdiction. What grounds can lead to the revocation of a notarial commission? So, hindi naman absolute yan na pagka ang notarial commission ina-award yan ng judges, ng mga executive judge sa isang particular na territorial jurisdiction. So hindi naman pagkabigay ng judge yan absolute ng sayo yan, parang privilege pa rin yan, pwede yang i-revoke anytime. On what grounds? First is failure to keep a notarial register. Second is failure to make proper entries sa register mo. Third, failure to send copies of entries to the executive judge. Failure to affix the date of expiration of the commission to acknowledgements. Failure to submit a filled notarial register to the executive judge. So pag puno na yung notarial register mo, kailangan mong balik dun sa judge, sa executive judge. Failure to make a report to the executive judge. Yung reportorial requirement na sinasabi natin kanina, yung weekly tsaka monthly. Failure to require, monthly pa lang. Failure to require the presence of a principal. Failure to properly identify a principal. Execution of a false or incomplete certificate, knowingly performing or failing to perform prohibited or mandated acts, and any other dereliction or act judged by the executive judge as good cause for revocation or administrative sanction. What is the consequence of an incomplete or deficient notarial certificate? It is as if there is no acknowledgement and the document remains a private instrument. So parang hindi siya na-notaryohan. Yun lang ibig sabihin yan. What does it indicate when a deed of donation is notarized without determining the presence or qualification of the affiants? Okay, sabi rito, based on the rules, it is tantamount to gross negligence and ignorance of the rules on notarial practice. Why is the personal appearance of the person executing the document important for a notary public? Siyempre, to verify the genuineness of the signature and to ascertain that the document is the party's free act or deed. So again, to verify the genuineness of the signature ng parties and that they acted on their free will. What penalties can a lawyer commission as a notary public face for failing to discharge their duties. Their notarial commissions may be revoked. Disqualifications from being a commissioned notary public for 2 years, and suspension from the practice of law for 1 year. What sources can a notary public use to identify an individual? Based sa practice, at least one current identification document issued by an official agency, yung ID natin, or the oath or affirmation of a credible witness. Give examples of identification documents accepted by a notary public. Yung mga government-issued IDs, passport, driver's license, PRC, ID, NBI clearance, police clearance, voter's ID, GSIS e-card, and the like. What is the reason for excluding community tax certificate as proof of identity? So, dati kasama yan as na pwedeng sedula. Tawag dyan sedula eh. Pwede siyang proof of identity. Dati. Under the notarial rules, hindi na siya pwedeng gamitin as proof of identity. Bakit? Because of its inherent unreliability. Kasi kahit saan pwede nang gawin yun eh. What actions can lead to administrative sanctions against a notary public? Okay. Administrative sanctions. Naisip ko lang is revocation. Revocation ng commission mo as a notary public. Other than that, yung mga nabanggit natin kanina, tulad nung disqualification from being a commissioned notary public for 2 years, tsaka suspension from the private practice of law. What is the consequence of an order imposing disciplinary sanctions to a notary public? Okay. So if there's a disciplinary sanction na issue na against a notary public, it's considered as immediately executory pending appeal. Where are the names of the notaries who have been administratively sanctioned posted? So, ipapost yan ng executive judge, yung mga sanctioned notaries. Makikita yan normally sa mga offices ng executive judges and the Clerk of Court. What criminal actions can result in prosecution regarding a notary public? So, if you impersonate a notary public, criminal action yan or criminal prosecution ang resulta. Tampering of notarial records, or influencing official misconduct. It will result to the prosecution with regards to notarial acts. So let's go. So we're done with the notarial practice rule. Let's go to judicial ethics. Okay, so judicial ethics. It is ito yung rules of ethics with respect to judges naman of the tapos na tayo sa sa bar. Ito na yung bench. Dito na tayo sa bench. So let's proceed. What is the purpose of the new judicial conduct? New Code of Judicial Conduct. It is to update and correlate the Code of Judicial Conduct and the Canons of Judicial Ethics. So dalawa kasi yung nag-govern na rules for judges noong unang panahon, Code of Judicial Conduct and Canons of Judicial Ethics, and to align the universal clamor for a universal Code of Judicial Ethics. Parang yung sa dati sa mga abogado, there was this code of CPR, Code of Professional Responsibility, and meron pa yung Canons of Professional Conduct ba yun, CPC. Yun. Thankfully, pinag-isa na lang nila. Currently, yung CIPRA, yung nag-govern sa lawyers. And now, sa judges, the new Code of Judicial Conduct. What principles is the judicial code of what principles ba yan? What principle is the new Code of Judicial Conduct founded on? Okay. There are 3 principles on which the new Code of Judicial Conduct is founded on. First, the universal recognition that a competent, independent, and impartial judiciary is essential. Second, public confidence in the judicial system and in the moral authority and integrity of the judiciary is of utmost importance. And third, judges should respect and honor the judicial office as a public trust and strive to enhance and maintain confidence in the judicial system. When was the Code of Judicial Conduct promulgated for the Philippine Judiciary? April 27, 2004. So, mas matanda pa to. Siguro, talaga ba? Parang hindi naman. Anyway, which documents does the new Code of Judicial Conduct supersede? So, it supersedes the Canons of Judicial Ethics, which was promulgated in 1946, and the Code of Judicial Conduct, which was promulgated in 1989. In what event will the Canons of Judicial Ethics and Code of Judicial Conduct be applicable? So, hindi sila entirely repealed, parang ganun yung ibig niya sabihin. So, in case of deficiency or absence of any specific provisions from the new Code of Judicial Conduct, pwede mag-apply ang Canons of Judicial Ethics and Code of Judicial Conduct. What does the Canon of Independence mandate for judges? Okay. The Canon of Independence, basically lang sinasabi niya, judges should be free from external influence, administer justice impartially and without delay, and be vigilant to any attempt to undermine the institutional freedom of the judiciary. Staging a rally demanding a warrant of arrest sufficient excuse for a judge's haste in fixing bail without a hearing? Answer is no. Bakit? Because judges should be independent. Should follow the Canon of Independence. What is the consequence of a judge admitting to succumbing to pressure from a national official in deciding a case in favor of the complainant? Okay, the consequence would be dismissal from service with forfeiture of retirement benefits with prejudice to any reinstatement in any branch of the government or its instrumentalities. What does the Canon of Integrity require of judges? So there's a Canon of Integrity dun sa Code of Judicial Conduct. It requires judges to ensure that their conduct is above reproach and perceived as such. So, hindi lang above reproach, it should be perceived as such. Or should be perceived as above reproach. What does integrity encompass for judges? Both the proper discharge of the judicial office and their personal demeanor. What must judges adhere to in terms of conduct? Like lawyers also, the highest standard of conduct should be adhered to by judges. What must a judge be in addition to being impartial? So, is it enough for judges to be impartial? No. Based on the rules, based on the code, they should also appear impartial. What is the importance of the canon of impartiality in judicial office? Impartiality is essential to the proper discharge of the judicial office and applies not only to the decision itself but also to the process by which the decision is made. So sabi natin kanina, a judge, in addition to being impartial, should also appear impartial. So dapat wala kayong makikita na masyadong judges na nakikipag fraternize with other lawyers. Kasama lang nila either judges or justices or their peers sa bench because they must also appear impartial. Yung walang nag-i-influence sa kanila. Next question. What should a judge prioritize when making a decision? Okay, a judge should prioritize the application of law over his own personal beliefs or preferences. Is it appropriate for a court of law to engage in debate on morality or propriety of a sentence? The answer is no. A court of law is not a place for a protracted debate on the morality or propriety of a sentence. So kung ano lang nasa batas, yun yung dapat na i-discuss doon. What is the importance of the canon of propriety for judges? Propriety and the appearance of propriety are essential to the performance of all activities of a judge. So again, a judge should not only be proper in his demeanor and his standards, but also appear to be proper. So hindi na siya pwedeng makipag-inuman sa mga tambay sa kanto. Hindi na siya pwedeng makimarites dun sa kapitbahay. He should observe propriety and the appearance of propriety because it is essential to the performance of all the activities of judges. How should judges conduct themselves in relation to their office? Well, judges shall conduct themselves in a way consistent to the dignity of their office. So, above reproach parati. What are judges entitled to in terms of freedom of expression? Okay. While judges are still entitled to the freedoms provided in the Constitution, they should also consider the canons specified in the Code of Judicial Conduct. So, limited pa rin sila. Limited pa rin yung galaw nila. What activities can judges engage in outside of their judicial duties? Based dun sa Code of Judicial Conduct, judges can write books, lecture, teach, participate in activities concerning the law, the administration of justice, and the legal system. What should judges be cautious about when using social media? Okay. I'm not sure if andun na yan sa but again, trying to correlate the canons stated in the Code of Judicial Conduct in this question. Well, judges and court personnel should be cautious and circumspect in posting photos, liking posts and making comments in public or on social media. Bakit? Kasi nga, they should observe propriety and appear proper in all instances. What is the canon of equality? Okay, equality. It is a set of guidelines for judges to ensure that they exercise equal treatment before the courts. So, yun. What should judges avoid in the performance of their judicial duties? Siyempre, bawal silang magpakita ng bias on irrelevant grounds. What should judges do in carrying out their duties and responsibilities? First, they should consider all parties without differentiation or yun nga, bawal ka magpakita ng bias, especially on irrelevant grounds. What is the responsibility of judges regarding their staff? Okay. Judges should not knowingly permit differentiation between the persons on irrelevant grounds. So yung responsibility nila to impartiality, I mean on equality, dapat mag-trickle down yun sa staff nila. What is the expectation for lawyers in proceedings before courts? Lawyers, based on sa code, should refrain from manifesting bias or prejudice based on irrelevant grounds, except on those legally relevant to the issue and subject to legitimate advocacy of their own cases. What takes precedence over all activities for judges? Siyempre, yung judicial duties nila. Besides judicial functions, what other tasks should judges devote their professional activity to? Anything relevant to the operations of their court or sala. What steps should judges take to maintain their knowledge, skills, and personal qualities? Well, I think there's the Judicial Academy of the Philippines nag-offer ng continuing legal education for judges sa mga bagong batas. They should take the necessary steps to engage the services of that institution to maintain their knowledge, skills, and qualities. How should judges perform their duties efficiently, fairly, and with reasonable promptness? How should judges maintain order and decorum in court proceedings? They should be, patient, dignified, courteous to litigants, witnesses, and lawyers. Can judges engage in a conduct incompatible with the diligent discharge of their judicial duties? Siyempre, hindi. Shall not engage in such conduct. What action should be taken if a judge is unfit to discharge the functions of the office due to a medical disability of the mind? He may be subject to a dismissal from service. What is the consequence of a judge's failure to file a signed decision with the Clerk of Court for over 170 days? So based to sa, I think, jurisprudence then, it is a violation of the duty to administer justice without undue delay. How may a judge be disqualified to hear a case? How may a judge be disqualified? Ano yung mga disqualification ng judges if they are to hear a case? First, there's a compulsory disqualification, and second, voluntary disqualification. How may a judge be compulsory disqualified to hear a case? If he has actual bias or prejudice. Second, if he has economic interest, not only himself but also his family. Third, if he is reviewing his own case. And last, if he acted or previously served as counsel dun sa kaso na yun. What are circumstances? Under what circumstances should judges disqualify themselves? So this is voluntary, voluntary disqualification. So ito yung instances where a judge should excuse themselves from presiding over a case. First, actual bias or prejudice. Alam nung judge na may bias or prejudice siya, and hindi niya kahit appearance of bias or prejudice. Second, economic interests of the judge. Third, reviewing of their own cases. And again, previously acting as counsel. So pareho lang. Kung ano yung compulsory tsaka voluntary, pareho lang din yung grounds. Yung isa, pwede mong pilitin or force a judge to inhibit. Whereas yung isa, yung judge na yung on his own volition na mag-i-inhibit ang sarili niya. When can a judge voluntarily disqualify themselves in a case? Ayan. When there are just or valid reasons other than those mentioned as compulsory grounds for disqualification. So a judge can disqualify or excuse himself from presiding over a case. Tawag dito normally personal reasons or health reasons. So yan, they can voluntarily disqualify themselves from hearing the case. Other than those stated in as a grounds for compulsory disqualification or voluntary disqualification. What are the importance of maintaining trust and faith as a judicial officer? Okay, this is to ensure the fairness and impartiality of the judicial process. So I think that's it. Yeah, that's it. Okay, so I'll see you on the final exam. Kayo na yung mag-ano sa akin kung ano yung please Mr. Bass, contact me or email me kung ano yung preferred na date ng class. Hopefully hindi naman ganon ka-late para makapag-review kayo sa or ma-prioritize nyo yung mga major subjects nyo. Okay, so I'll see you then. It's been a pleasure. Right?